Welcome to my channel. Please like, comment, and subscribe. In this video, we are going to talk about the Death on the High Seas Act. If you have lost a loved one at sea and the cause of death was negligence, default, or wrongful act, you may be entitled to pecuniary damages through the Death on the High Seas Act, or DOHSA. The act passed in 1920 as a way to provide compensation for the families of seamen killed on the job while out to sea. Being out to sea is always risky, and when there is a negligence of default of some kind involved, it increases the risk even more. If your loved ones died in this way, know your rights and rely on an experienced maritime lawyer to help you make a claim. Qualifying for DOHSA compensation. This federal act provides compensation for the surviving dependent family members of those workers who die out at sea. The death must have occurred 3 or more nautical miles from the U.S. shore. The act also only covers those who died working aboard a commercial vessel. Privately owned and non-commercial ships are not covered by DOHSA. Anyone who qualifies as a dependent of the deceased may file a claim under the DOHSA to seek compensation. This means someone who was being financially supported by the killed worker and could include a spouse, children, siblings, parents and grandparents, or grandchildren are dependent. Filing a claim must be able to prove that negligence, inappropriate judgment, or a wrongful act on the part of the ship owner contributed to the death of the seaman. It also must be proven that the vessel was unseaworthy. There are many situations that could qualify under these guidelines. For instance, if your loved one worked aboard a ship with equipment that was not properly maintained, that represent both negligence on the part of the owner and unseaworthy vessels. If that equipment caused an accident that led to death of a worker, his or her dependents could make a claim through DOHSA. The DOHSA or DOHSA also applies to commercial aircraft and aviation accident if a plane crash occurs beyond 12 nautical miles from the U.S. shore. Dependents of those killed can seek non-pecuniary damages. This means damages for things like the loss of comfort, companionship, and care. Compensation under the DOHSA. If a loved one of a deceased seaman can prove that the owner was negligent and that the vessel was unseaworthy, he or she can make a claim through the DOHSA for the compensation. The law states that those claimants will be apportioned recovery according to the extent of the loss. Pecuniary damages are awarded to cover a number of costs related to the loss of seamen. This may include lost current and future financial support for dependents, future costs, expenses for any counseling related to death, lost wages owed to spouse or other dependent, including pension and benefits, and the cost of household services provided by the deceased, like a lawn care or maintenance. The next discussion is about limitation of a DOHSA compensation. The DOHSA does not cover all costs related to deceased or to all family members of that workers. An ex-spouse is not entitled to recover any damages, nor are adult children not living at home. Dependent children may receive compensation until they are 18 or longer if they attend college or another higher education institution. The DOHSA also does not provide for non-pecuniary damages except for the dependents of the deceased who meets the aviation accident requirements. These types of damages for mental anguish, pain and suffering, and grief are not covered by DOHSA, but they are covered by other federal maritime laws like the Jones Act. There is also a statute of limitation for making a claim under this act. A claim must be made within the 3 years of the fatal accident. The process of determining negligence and of calculating lost wages and other factors to decide on compensation are complicated and take time. For this reason, if you need to file a DOHSA claim, it is recommended that you do it as soon as after the death as possible. And then Death of High Sea Act and contributory negligence in situation in which the deceased was negligent in the accident in some way, dependent family members are not denied compensation. The negligence on the part of the deceased can contribute to his or her death is considered, though. It can cause the amount of damages recovered by the dependents to be reduced from what it would have been if the deceased was found not to be negligent. If you have lost someone to the high seas, the loss may be devastating. It can be tough to navigate the legal process of filing for the damages you are owed while also coping with your grief. To find out what your rights are in your specific case, rely on the assistance of an attorney experienced with maritime law and the Death of High Seas Act. I think that's all, guys, the information that I can share to you. I hope this can help you, and if you need information about maritime law or any information about maritime topic, you are in the right channel, because in this channel we talk about it a lot. And if you guys want us to talk about or discuss about the information that you need about maritime topic, you can just drop your comment below on the comment section, and later when we have a chance we will talk about it. And also, if you guys have a question, you can just drop your question in the comment section, and later when we have the answer we will answer your question too. And also, don't forget to share this video to your family, friends, and your loved ones. Maybe they need information about maritime topic. When you share this video to them, it means you already helped them to get through their problem. I think that's all, guys, the information that I can share to you. I hope you can take advantage from the information that I have shared to you. Don't forget to give like, comment, and subscribe. Bye bye.